Good day, everyone. Today we'll be discussing form, interpretation, and defective contracts under the Civil Code of the Philippines, specifically Articles 1356 to 1402. Let's begin with the form of contracts. Under Article 1356, the general rule is simple. Contracts are valid in any form, as long as the essential elements are present. And what are these elements? Consent, object, and cause. If those three are present, you already have a valid contract. So yes, even a verbal agreement can be valid. Let me give you an example. Suppose A agrees to sell his notebook to B for 100, and B agrees. Even if nothing is written, that's already a valid contract. But you have to be careful. Because under the statute of fraud, sale of goods worth 500 or more must be in writing. So suppose A agrees to sell his laptop to B for 20,000 verbally, and B agrees. Does it render the contract invalid? The answer is no. Because a contract falling under the statute of frauds is not void, but unenforceable unless evidenced by a written note or memorandum. This just simply means that a written contract is required only for enforceability, not validity. You have to learn that there are situations where the law really requires a specific form, like putting the agreement in writing. Under Article 1357, when the law requires a specific form, like a written document, the parties can compel each other to follow that form. And Article 1358 specifies certain contracts that must appear in a public instrument. This includes sale of land, transfer of real property rights, powers of attorney, and renunciation of inheritance. For example, A sells land to B, but they only agree orally. The contract is still valid, but B may have difficulty registering ownership without a notarized document. Remember that lack of required form does not invalidate the contract. It only affects enforceability or convenience. From an accounting perspective, this is also important, because even if there's no written contract, if there is delivery, if there is payment, the transaction may still be recorded. Form only affects audit evidence and legal enforceability, but not necessarily the economic substance of the transaction. Let's give you an accounting example. A company buys equipment through a verbal agreement. The transaction may still be recorded in the books if there is sufficient evidence, like delivery and payment, even without a formal contract. Now let's move on to interpretation of contracts, under Articles 1370 to 1379. The Civil Code provides under Article 1370 that if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. And if the words appear to be contrary to the evident intention of the parties, the latter shall prevail over the former. Basically, the primary rule under the Civil Code is this. If the terms are clear, follow the literal meaning. No need to overthink. Example. A contract states that payment must be made on March 30th. The obligation must be fulfilled exactly on that date. No interpretation needed. But what if the wording is vague? What if there's ambiguity? Let's say the contract says, delivery will be made soon. Now what does soon mean? This is where interpretation comes in. We now look at the intention of the parties even beyond the written words and their actions before and after the contract. So if, in previous transactions, delivery usually happens within 3 days, then soon might mean the same thing. We also consider the whole contract, not just one clause, the nature of the transaction and industry practice or custom. There's also other important rules you need to consider. One is, consider the context and circumstances. Example. If the contract involves perishable goods, soon may mean within 1 to 2 days. Another one is, if there's ambiguity, it is interpreted against the party who caused it. Example. If A drafted the contract and used unclear wording, the interpretation will favor B. So if one party drafted the contract and made it unclear, they bear the consequences. Another core rule in interpretation of contracts is to resolve doubts in favor of greatest reciprocity or least transmission right. This rule has 2 parts. The first one is for gratuitous contracts, which means that there's no payment made and may be a one-sided benefit. For an instance, a donation. The rule is that we should interpret it in a way that gives less benefit to the receiver, because one party is giving something for free, and the law protects the giver from giving more than intended. Example. A donates land to B. Contract says, includes improvements, but unclear if that includes a building worth 5 million. Then we apply the rule. We'll choose interpretation with lease transfer, so maybe exclude the building unless clearly included. The second one is for onerous contracts, which involve payment and benefit for both parties. In this case, we should interpret it in a way that considers the greatest reciprocity, or to put it simply, in a way that is most fair and balanced to both parties. Why? Because both parties are giving and receiving value, and the law wants fair exchange. For example, A sells goods to B, and contract is unclear whether partial delivery is allowed. In this case, we should apply rule of greatest reciprocity. Choose interpretation that benefits both sides fairly. Maybe allow partial delivery as long as payment is proportional. Last core rule is that consider customs and usage. For an instance, in construction contracts, standard industry practices may define unclear terms. For example, if a construction contract says, the contractor must complete the structure in a reasonable time. What is reasonable time? Instead of guessing, we look at industry practice. Maybe similar projects usually take 6 months. That becomes the basis for interpretation. In accounting, interpretation is crucial because it affects revenue recognition, timing, and measurement under IFRS 15. For the part 3 of this discussion, we will talk about reformation. This is a concept students often confuse with annulment, so listen carefully. Under the Civil Code of the Philippines specifically, Articles 1359-1369, reformation is a legal remedy where a written contract is corrected so that it reflects the true agreement of the parties. So take note, the contract is valid. The problem is only in the written document. And reformation applies when the true intention of the parties is clear, but the written document does not reflect it. So let's say A and B agreed on a price of $500,000, but the written contract mistakenly states $50,000. The remedy here is reformation, as it can correct the document to reflect $500,000. Now, why does this happen? This may be due to mistake, fraud, accident, or inequitable conduct. Let's clarify the differences. Reformation fixes the document, while annulment cancels the contract. But we have to know that reformation is not always allowed, only under certain circumstances, such as when the contract is void, the agreement itself is illegal, or it is a simple donation without conditions. In accounting, reformation may change the measurement of transactions, but not the existence of the contract itself. Here's an accounting example. If a contract amount is corrected through reformation, the company adjusts the figures, but they don't remove the transaction. Now, for the last part of this discussion, let's talk about defective contracts. Under the Civil Code of the Philippines, defective contracts are contracts that have some legal flaw, but not all are treated the same. The law classifies them into 4 types, each with different effects and remedies. Let's discuss it. The first one is rescissible contracts. These are contracts that are valid and binding, but may be rescinded due to damage or prejudice. The key idea here is, contract is perfectly valid, but causes economic damage to a party or third person. Common grounds of this kind of contract involves economic loss or lesion and fraud against creditors. Example, a guardian sells a minor's property at a very low price. The contract is valid, but it may be rescinded due to economic loss, lesion. Remember the key point. Rescissible contracts are valid until rescinded, and it must be filed within 4 years. The second one is voidable contracts. Now, voidable contracts involve issues with consent, such as incapacity, mistake, violence, or intimidation, fraud. For example, a minor enters into a contract. This is voidable due to incapacity. Another example is when A signs a contract because of threats. This is voidable due to intimidation. The key points you need to remember here are, voidable contracts are valid and binding unless annulled, and because of this, the law allows it to be ratified. But ratification is valid only if the defect, for instance, intimidation, fraud, minority, is already removed. The party ratifying has full knowledge of the defect, and the party acts freely. For example, if a minor enters into a contract, it is voidable. But when the minor reaches legal age and chooses to honor the contract, that act ratifies it, making it fully valid. Now, for the third type, unenforceable contracts. These are contracts that cannot be enforced in court unless ratified. Examples of this contract includes unauthorized contracts, violations of the statute of frauds, or both parties are incapacitated. Examples: A sells B's property without authority. Oral agreement for sale of land violates statute of frauds. Both parties are minors. Just remember the key point. These contracts are not enforceable unless ratified. For the last one, void contracts. Void contracts are contracts that have no legal effect at all. These include illegal object or purpose. Example, contract to sell illegal drugs. Absolutely simulated contracts. Contracts prohibited by law. And here's the key concept I want you to really understand. Since a void contract has no legal effect at all, it is treated as if it never existed. And the action to declare nullity does not prescribe. What does it mean? Under the Civil Code of the Philippines, when we say that an action to declare the nullity of a void contract does not prescribe, it means that there is no time limit for filing a case to question the validity of that contract. A void contract is considered inexistent from the very beginning, as if it never had any legal effect. Because of this, the law does not allow the passage of time to validate or cure the defect. Even if many years have already passed, the contract can still be challenged in court. For example, if a contract involves an illegal object, any party can file an action to declare it void at any time, whether after 5, 10, or even 50 years. Because the law will never allow something illegal to become valid just because time has passed. After discussing different types of defective contracts, let's make an accounting integration. It is important to know how these matters of discussions relate to our majors, right? Now let's connect everything to accounting. For rescissible and voidable contracts, these may still be recognized in the books but require disclosures. For example, a sale may still be recorded but disclosed as subject to cancellation. For the unenforceable contracts, recognition of this depends on ratification. Example, revenue is recognized only after the contract becomes enforceable, and for the void contracts, no revenue will be recognized, assets and liabilities must be derecognized, and risks must be disclosed. Example, illegal transaction was found, the entity shall remove it from books entirely. Now, to summarize our discussion, here's a quick recap just for you. Form is generally not required for validity, but may affect enforceability. Interpretation focuses on true intention. Reformation corrects the document, not the agreement. Defective contracts vary in effect, from valid but rescissible to completely void. Understanding these concepts is essential not only in law, but also in financial reporting and decision-making. Thank you for listening, and I hope you learned something from this video lecture. See you in the next module.